routine that we have to go through? Good, because I don't.
Good evening. My name is Steve Pearson. I'm the zoning administrator for the City of Athens, Ohio. This is a rescheduled meeting of the regular April and May meetings of the Board of Zoning Appeals. We had hoped for 5 members tonight. There are only 4 that are here. We do have an agenda, though, of 4 cases. Whenever there are less than 5 members, each appellant has the opportunity to have their case continued until the next meeting, which hopefully will be the regularly scheduled meeting of June 13th. It takes 3 votes in the affirmative to have a variance approved or a temporary use approved or a substitution of a nonconforming use approved. There are 4 board members here tonight, just so everyone knows, everyone in the audience. Greg Lavelle is here. He's not feeling well. I spoke to Gary Hunter about would he have the ability to be in the building and watch the proceedings on television and then actually come to vote. And Gary said he thought that would be fine. So Mr. Lavelle is close by and listening to everything that's going on right now. So there are 4 cases tonight. 30 Westfield Place, a request for temporary use. 18 North May Avenue, a request for a front setback variance. 52 Columbia, a request for a parking variance. And the 4th case is 18.5 Palmer, request for substitution of a nonconforming use. So I suppose at this time, is there anyone who knows for sure that they don't want to proceed? So that being the case, we'll start out with the first case, 0610T, Zone R3, 30 Westfield Place. Cecilia Hansen is the appellant. So, and John, if you've got that little intro blurb that I've written for the board, if you could read that about testimony under oath and
Okay.
powers of the board, I'd appreciate that. Thank you.
So you're making me the chair tonight?
Yes. You said you had the blurb. You could
Okay.
share it, or you could each read a sentence.
Okay, good evening. This is the meeting of the Athens Board of Zoning Appeals. This meeting is called to order at this time, which is 7:20 on May 26, 2006. The board consists of 5 members and 1 alternate. The alternate takes full part in discussions of the board and becomes a voting member in the absence or a conflict of interest of a regular member. Present this evening are Mr. Roger Gruser, Mr. David Chafee, Mr. Greg Lavelle, who is in the other room, and he is watching the proceedings. And I am John Golsey, acting chair for tonight. Also present on this floor are Mr. Steve Pearson, Athens zoning administrator, and we don't have a secretary. Okay, who is taking the notes tonight? So who is taking the minutes tonight?
Well, what he'll do is he'll take a recording.
Recording, okay, very good.
And do the minutes off of it that way.
The board operates according to the following procedure. The chair will review the file. The zoning administrator will cite the specifics of the refusal. The appellant or a representative will then be asked to clarify or provide additional information. Testimony will be taken from those who would want to speak in support of the appellant, provide general comments, or speak in opposition. Following all testimonies, the appellant or a representative will be given a chance for rebuttal. Discussion from the floor will be closed. The board will deliberate and render a decision. The board has the power to grant variances according to the Athens City Code Section 230703B, Athens City Code Section 230910C, indicates the variance shall be granted in the spirit of the code and not contrary to the public interest or public safety. In granting a variance, the board is required to find beyond reasonable doubt that each and every one of the following 6 criteria is met. 1. practical difficulty or undue hardship. There must exist a practical difficulty or undue hardship caused by exceptional conditions pertaining to the specific piece of property. 2. Exceptional circumstances. There must exist exceptional circumstances or conditions applying to the property or its intended use that do not in general apply to properties in the same zoning district. Number 3, preservation of equal property rights. It must be determined that the literal interpretation of the code would deprive the appellant of rights commonly enjoyed by others in the same vicinity, while granting the variance would not convey any special privilege. Minimum variance. It must be determined that the variance is minimum required to make possible the reasonable use of the property. Number 5, absence of detriment. It must be determined that the granting of the variance will not be of substantial detriment to adjacent properties, nor impair the principles of the code. Number 6, not a general nature. The variance sought must not be of a general or recurrent nature such that the situation would more reasonably be handled by changing the law. The board also has the power to hear and decide applications for conditional use, substitution for non-conforming use, temporary uses, and appeals where it is alleged by the appellant that there is an error in the decision made by the zoning administrator regarding enforcement and interpretation of the code. Any person who is aggravated or aggrieved by the decision of the board may file an appeal to the Court of Common Pleas. Such petition must be filed within 30 days after the mailing of the board's resolution to the appellant. There are 4 cases on the agenda today. The board also requires that testimony be taken under oath. Anyone wishing to speak, please stand up and confirm. Do you swear that the testimony you will give to be truth, the whole truth, and nothing but the truth?
Yeah, I do.
Thank you. Have a seat. Case number 1, case number 06-10T, address 30 Westfield Place, Zone R3, Cecilia Hansen, appellant. Appellant is requesting a temporary use of 1 year to permit conversion of an attached single-family dwelling to a rental housekeeping unit with occupancy of 2 unrelated persons with 1 accessible and 1 non-accessible parking space where accessibility to all parking spaces is required. At this point, I would like to ask Mr. Steve Pearson to come to the podium and give us some information about this continued case.
Thank you. Excuse me. This case was heard 3 months ago in a little different format. Ms. Hansen was here requesting a variance to permit conversion to a rental unit that she owns at Westfield Place into a rental, and those variances go forever with the property. The problem here is that the problem's not that there's not enough parking spaces. It's 1 for each permitted occupant. There are 2 parking spaces. She's only asking for 2 tenants. The problem is that in an R3 zone or any zone other than an R1 or an R2 zone, all the cars have to be able to get out to the street without moving another car. So for some reason, the way the code's written, that accessibility requirement is not use-driven, it's zone-driven. If this were in a R1 or R2 zone, we wouldn't even be here tonight. So it has to do with the zone. It's a problem with the zone and not with the use. The board refused the request for a variance, like I say, a couple meetings ago, and there was some discussion about was there an alternative way that Ms. Hansen could temporarily use the property as a rental. She had indicated that she was, her studies, her academic studies had taken her out of the area to the Columbus area for about a year, a little over a year and a half, I believe, something like that. And I'd mentioned to the board that a request for a temporary use could be a possibility. You had recently reviewed a case like that on West State Street, where Mesta Properties, the Coladas family, had the sons had obtained a property where their mother used to reside. They really didn't want to turn it into a rental, but they also didn't want it to just sit empty for an extended period of time until it was sold. So the board reviewed that and granted a temporary use permit to let them use it as a rental with stacked parking for up to 1 year. That property has since sold, and the new owner has actually installed compliant parking. So they were afforded relief for that short amount of time, either to turn the property over to sell it, and in Ms. Hanson's case, just a short amount of time for some relief so she could rent it until she comes back to the area. Temporary uses. The board can grant temporary uses in any zone for purposes that conform to the regulations, provided that the board finds such use to be of just a temporary nature, not involve the erection of a substantial structure, and that it is unlikely to cause substantial detriment to the public. Temporary uses are granted for 1 year and may have attached conditions to safeguard public health, safety, morals, and general welfare. Permits where there's a temporary use permit requested for an extension more than a year has to first be reviewed by the Planning Commission, and they send a recommendation back to the board. The board then can grant extension of a temporary use permit for an additional 2 years, or for essentially then for a total of 3 years, up to 3 years. So that's why we're back tonight. We were looking at the last meeting for some alternative to try to afford Ms. Hanson some relief until she's able to come from Columbus and come back to town.
Okay, thanks. I just want to remind our board members that this is not a variance, so we don't need to do the 6 findings. And do we need any more additional?
Well, that's why I read that section. The things that you probably need to discuss.
Okay.
There are some things here that it's just of a temporary nature, which I think has been presented. Does not involve the erection of a substantial structure, and there's no construction involved, and that it is unlikely to cause detriment to the public. The only thing that I could think any detriment might be at the variance request meeting, people were talking about traffic problems, but in this case, there's no more cars there than would be there if Ms. Hanson were living there. It's just that oddity about the code about stacking cars behind each other. So it's not adding any more cars. As a matter of fact, it could be diminishing the number of cars. And those are the 3 things. It's just temporary nature, no structure, and no detriment to the public.
Okay, thanks. Ms. Hanson, would you like to come to the podium? State your name and address, please. And you must be close to graduation in Columbus anyway, right?
Well, 1 more year, and I'll be here. My name is Cecilia Hansen, and I live at, I own 30 Westfield Place. I'm requesting a temporary permit just till I can complete my clerkship, which will be at the end of next year. And I will be back here summer of 2007 to return back to my home.
Okay.
And so it is just for temporary relief until I can come back to Athens, which I am definitely going to be doing. So I guess I just want to thank you guys once again for hearing me.
I mean, you came in here about 2 months ago, right? What has been the situations in the last 2 months? You've been in Columbus, right?
Yes.
And do you have a renter, somebody in there right now?
I have, yes, some people that are, that are living there right now. Yes.
How many people are there right now?
2 right now.
2 people. And how is the traffic going right now?
Because they're studying for boards, there's no real big traffic. They're just pretty much using it just to sleep and eat.
So there's been no complaint or concerns from the neighbors, or as far as
actually the neighbors came up to me at the end of the last meeting and stated that they weren't even sure if people were living there because they haven't really seen a lot of traffic coming back and forth.
And both cars are right now in the driveway?
Yes, one is in the garage, and the second one is in the driveway.
Okay. How do we contact Greg? Greg, any question?
I'll find out. I do have one other thing I'd like to add.
Sure.
Just so you know, the code does allow for occupancy of a structure by someone other than the owner for up to 6 months. If you go on extended vacation or you go on sabbatical, you don't need a rental permit for up to 6 months. So
Okay.
essentially, that's the time frame Ms. Hanson is working in right now. It's just that it's going to be extended beyond that 6 months that's permitted
Okay.
for essentially someone just to housekeep for you until you return.
Okay.
So,
The housekeeping is only for 6 months.
right.
Yeah, okay.
Right. So that's the time frame she's been working in so far. So
Okay.
there's no violation at the moment.
Okay.
And I'll go in and see if Mr. Lavelle's got any questions.
Okay. Roger, any questions from?
I have no questions whatsoever. It's all very clear.
Yeah. And have you signed any contract with these people for over 6 months or?
No,
Yes,
not
okay.
for over 6 months.
Anything else you want to add?
That's pretty much it. Thank
Okay.
you.
Thank you very much.
Greg said he's fine.
Okay. Is there anyone present who would like to speak on her behalf? Or in general comments? General comments. Paul?
Paul Wild, 3 Mary Street. I think the biggest concern I was hearing in the last meeting, I was at that meeting was it only 3 months ago? Was the permanence of a variance. And you can see this being a temporary nature is not the concern. I think they were saying there was no problem right now, but, the longevity of a variance going with the property. So
Okay.
it sounds like it's a different animal here.
Okay, thanks. Is there anyone who would like to speak in opposition? Ms. Hanson, would you like to add anything more? This is your last chance. Please come to the podium.
For the most part, I think everything has been made perfectly clear. I appreciate you guys hearing me the last time and then bringing me back this time. And it really isn't, don't want to change, I don't want a variance. It's just a special circumstance which will resolve after June of, or summer of 2007. I will return back to my home, so
Okay,
this
thank
will
you.
not be a problem.
And I also want to apologize to you and all the other appellants for this delays that is being going on, so thank you. Okay, the discussion from the floor is closed. David, Roger, any
I think we can vote.
further? Well, we need to kind of make a motion, I think.
I move that we grant a temporary use permit for 1 year in the case of number 6-10T, Zone R3, located at 30 Westfield Place. Cecilia Hanson is the appellant.
Second?
This
Second.
is an attached
Oh.
single-family dwelling unit to a rental housekeeping unit with occupancy of 2 unrelated persons with 1 accessible and 1 non-accessible parking space where accessibility to all parking spaces is required.
Second?
Second?
Okay, great. I don't think there is anything we discussed, it seems that these people already been there for a couple months and there's been no
We
major
discussed it
problem.
pretty thoroughly, I
Yeah.
thought, 3 months ago.
And there's no detriment to the neighborhood and so on.
None
So-
of the residents who came
For,
to voice their
Well,
concerns
Soul
about the
Bloom were
variance
the
are
only
here this
one,
time.
and they said they had no concerns at all about
so,
temporary.
vote, Roger?
Yes.
Yes?
Yes. And Greg? Yes?
Yes.
And I also vote yes. So you've got your permit for 1 year to continue with the rental. Thank you.
Thanks for being so patient. Jeez.
Case number 2, case 06-11V for variance, property at 18 North May Avenue. The appellant is Douglas Westendal. Appellant is requesting a variance from section 23.11 table A schedule of bulk controls to permit the addition of a front porch to an existing single-family dwelling with a front yard setback of 22.5 feet, where 25 feet is the permitted minimum. Steve, please.
Several months ago, Mr. Whistler.
I'm sorry, excuse me.
Yeah.
We didn't get anything on this case, did we? I mean, I don't have anything.
Just the sketches that are in here.
Okay, it's just whatever we have in there, right?
Right, I thought I'd delivered those packets to you, but if
That
you want to wait
package
for just a
wasn't in my
minute.
package before.
We've got them right here.
There should be at least one in there. Sorry about that. I haven't gotten these to you, but I thought that I had.
Roger, and I guess David, you guys seen the case, right? You've looked at it, okay. Just want to make sure that Greg had a chance to look at it.
I suppose, first thing, and then you guys can look at this. Right here is a footprint of the existing house. There were a couple additions right here. There was already a stoop in front of the house, but it didn't have a roof over it. And so that's kind of what was there and what's going to be added on. I'll explain that in a little more detail in just a second. And then here's a little more specific detail of the floor plan. Hopefully I can explain the situation. There's Mr. Witzendahl owns an existing house, 18 North May Avenue. He came to my office quite a few weeks ago and presented to me a plan to renovate and add to the home. Everything looked pretty good. Setbacks were fine. Lot coverage was okay. But he wanted to put a roof over a stoop that was on the front of the house. The house is sitting and has, since its construction, been in compliance with the 25-foot front setback, but it was built without a covered front porch. And what he would like to do would be to add a porch. I believe it's 4.5 feet. It's just 4.5 feet deep from the front of the house, essentially just enough to get you out of the rain when you come up to the front door. So the house is sitting, say, at 27 feet, and the 4.5, though, takes it down where there's a 2.5 foot encroachment into that 25 feet. So instead of being 25 feet back, he's only 22.5 back. I want to say the right-of-way on May Avenue is 50 feet, so this is not very close to the curb line of the street at all. It's not like the streets, right up there. And if you're familiar with May Avenue, North May in particular, it's a fairly wide open, plenty of parking on the street kind of a thing where, actually, to be honest with you, 2.5 feet is pretty minimal variance, in my opinion, to ask for, just to cover the front stoop. The board's heard some case, not that you set precedent or anything like that. I don't want to give that impression because each case is a little bit different. But the board's heard cases recently on Morris Avenue, Maplewood, and Ohio Avenue. And variances were granted for those. Now, there's been other situations where variances were denied, but each case has its own, particular differences. So
From what I
there's a history
see,
of both refusals and
Is
approvals.
this only 4.5 feet? Is
Yeah.
only 4.5 feet deep, this porch?
Right,
Is
from the
it?
existing face of the house out to where this covered area is going to be is only 4.5 feet.
Okay.
So, that's
Yeah.
2.5 of these floor tiles right here. Each
Right.
one of these tiles is 2 feet.
Yeah.
So that's how much encroachment we're talking about into that 25 feet that's required.
Okay, thanks.
Mhm.
Mr. Westerhall, I apologize if I mispronounced your name. but-
very good.
Okay, okay, very good. Before you even start, I would like to ask, is 4.5 feet enough for you? I mean, that seems to be very
Well, I'm a little embarrassed because as I read through my submission, I see I'm looking for a 22.5-foot setback in one place, and I say 22 feet in another. But the depth of this porch, which would be enclosed, is 4.5 feet, which I guess is about that. But there's already, because of the configuration of the house, 4.5 feet starts something like 23 feet back, or 22.5, or 23.5 feet back from, I'm sorry, 28.5 feet back from the lot line. In other words, the house is recessed at the point where I'd like to build out 4 feet. So it actually only encroaches 2.5 or 3 feet into the setback area, depending on which place I'm right in my submission. So to be safe, 22 feet would be best, but I can live with the 22.5 if that's...
You need to state your name and address.
I'm terribly sorry. It's Douglas Wistendahl, 18 North Mace, Athens.
Okay. Please just take your case. Whatever you want to say.
Well, the situation is as follows. I've been granted a building permit to remodel and expand my house, and this particular portion of the house is currently a breezeway. It has no front porch. It has a brick wall with an archway going into the breezeway. With the remodeling that's been approved, that front area will actually be a living space. So without this small entranceway, I will walk directly from outside directly into a living area with absolutely no shelter or anything over it. I have not done measurements of my neighbors' houses, but as I sight down the front of my house, down the block, I see everybody's got a covered porch that extends at least 4 feet in or more. So I'm actually probably asking for a little less than what most of my neighbors have. And as I say, the setback from the lot line, instead of being the 25 feet required, would be 22.5 or 22, preferably, feet. The actual lot line is, if I recall correctly, approximately 15 feet from the curb. So the total area between the front of the house now and the curb is about 45 feet or so. So again, it's obviously your judgment, but it's a relatively small encroachment into the otherwise setback limitation. And the benefit to me, of course, would be that I would have a sheltered area to walk into my living space. I'd be able to insulate it, which I cannot do now with my brick wall. And again, I'm trying to do this in such a fashion that the house maintains its consistent look with the neighborhood. And I certainly can't imagine how it would in any way be detrimental to my neighbors, or in fact, all of them that I've spoken to said, well, whatever you want to do, we're sure it's going to be fine. So.
Okay. Thanks.
Thank you.
And thank you for being here on a Friday night.
Sure,
Appreciate it.
absolutely. Steve, can I ask you a quick question? It's always been kind of confusing for me, at least, that the 25-foot front setback, is it sometimes in the middle of the street, sometimes it's by the curb? Exactly which one is it for this case?
There are two different circumstances where the front setback's measured from. In platted subdivisions, which this is a platted subdivision, it's the distance back from the edge of the public right-of-way into the lot.
Okay.
As I mentioned, well, I'll just give you an example. If I'm pretty sure North May is 50 feet right-of-way. Let's say that there's 24 feet of pavement. I'm just going to guess because an average lane's 12 feet. When you subtract 24 from 50, that leaves 26. And generally speaking, the pavement's in the center of the right-of-way. So there's a reservation of grassed area for pedestrians to walk, for installation of public utilities, water, sewer, street lights, buried electric. So in a platted subdivision, your property doesn't go to the curb line of the street. It's back in the yard a little bit.
Okay.
So in that particular scenario that I gave you, there would be 13 feet of grass back from the curb line to the property line, and then the setback that's required would be an additional 25 feet.
Okay.
So I think as Mr. Wistendahl was alluding to, if that were the case, 25, 35, 37, 38 feet back.
Okay.
And,
So it is your office that determines that they're requesting a variance for 22 and a half or 22 or whatever, because parents
Whenever
wouldn't-
someone applies, they have to provide us the information. We base it on the application that they submit to us, so we basically put the onus on them to determine where the property line is at. If that's not possible, we try to do the best we can with best available data. City GIS, Athens County GIS. A lot of times, my office has been doing minor lot splits since 1996, and there's records clear back to 1987 here in City Hall. So a lot of times, I'm even able to go back and pull out actual surveys. But in this case, and it's fairly common on the east side of town where the topography is generally flat, that those pavement areas are centered in that right-of-way.
Okay, thanks.
And that's probably why it'd be a good idea to give that 6-inch latitude
Right.
for a 22-foot variance
Yeah,
for 22 feet instead of 22 and a half.
22, okay.
Allow a little wiggle
Note
room
that.
there.
Okay, thank you. Is there anyone in here who would like to speak on behalf of the appellant? Or in general comments? Or in opposition? Is there anything else you'd like to add to your,
No, except to say that I apologize for the confusion on the 22,
No, that's
22 and a
fine.
half.
That's explained all.
The width would be 4.5 feet, and I would
Right.
appreciate it.
Right,
I wouldn't want to violate inadvertently with the
that's
extra
fine,
half.
that's fine.
Thank you.
Thank you very much. I would like to entertain a motion on this case with changing 22 and a half to 22 feet. Dave?
Shall I make a motion?
Yeah.
I move in the case of 18 North May Avenue, case 06-11V, Zone R1, that we consider a request for a variance from section 23.11, Table A, schedule of bulk controls to permit the addition of a front porch to an existing single-family dwelling unit with a front yard setback of 22 and 1/2.
No,
22.
22 feet, where 25 feet is the permitted minimum.
I second.
Okay, let's go quickly over the findings. Practical difficulty or undue hardship. There must exist a practical difficulty or undue hardship caused by the exceptional conditions pertaining to the specific piece of property.
His front door will be exposed to the weather, and he won't have shelter for guests that are there. And then besides that, it sounds like it's going to be compatible with the other houses there. So if he can't do that, then he'd be experiencing a hardship with regards to the way the others are
I
constructed.
fully agree.
I
myself.
agree.
Yeah. Number two, exceptional circumstances. There must exist exceptional circumstances or conditions applying to the property or its intended use that do not in general apply to the properties in the same zoning district. It looks like the neighbors, they have the same kind of a
Other houses have
conditions.
porches.
Other houses have porches, yeah. Preservation of equal property rights. It must be determined that literal interpretation of the code would deprive the appellant of rights commonly enjoyed by others in the same vicinity, while granting the variance would not convey any special privilege. As appellant stated, I guess they all have porches and you should have. Minimum variance. It must be determined that the variance is the minimum required to make possible the reasonable use of the property.
It's certainly minimal.
I think-
Pretty minimal.
I agree. Absence of detriment. It must be determined that granting of the variance must not be of substantial detriment to adjacent properties nor impair the principles of the code.
Think of it.
I don't
It's
think
just
that
another
is
porch.
Yeah, it's a porch, yeah. And not of a general nature. The variance must not be of a general or recurring nature such that the situation would more reasonably be handled by the changing the law. I don't think we need to change the law for that. Dave? Voting
Are we
time.
voting? I vote yes.
Yes.
Yes, and I vote yes as well. You have the variance. Thank you.
Copy the resolution
Gentlemen, you ready for number 3? Roger, you ready for number 3?
Yeah.
Should they go on?
He said that we
You
could,
could ask again, I guess.
I'm just wondering if you wanted a break or something.
is Mr. Kerber here? And are you willing to have your appeal addressed by 4 instead of 5 members? And you realize that you need 3 votes?
You have
It's your
the right
decision.
to make a decision. Anytime we have less than 5 members, which is the full members, you have the right to either be heard or continue the case.
That's Friday, 13th of June.
This gentleman here asked, if I wanted to change like the size of the parking, and like, let's say it was denied today,
Uh-huh.
and I wanted to change the size of the parking, just reduce it by 2 feet, would that be an adequate change?
It must be a major change. That, I guess Steve can address that. Maybe you can answer this question, please.
Does it have to be major?
I'm not sure what,
If we
Mr.
deny your
Kerber
case,
might
you
be
have to wait
referring
for
to,
1
but-
year.
I guess if I could expand on a little bit. Mr. Kerber's been in my office looking at the parking requirements and looking at the possibilities of installing parking somewhere on the lot. Although I don't have an application for installation of additional parking, there is the potential to install parking at the rear of his property off of a platted alley. It's posted on each end that it be kept clear, so there's no one can park right on the alley or encumber the alley in any way. So that's additional discussion that he and I have had in recent times, recent days. And I think that might be what he's alluding to.
So he would have the option of coming back with a
If he-
different proposal.
If he could install 3 parking spaces, he wouldn't even have to come back to the board. So,
But he can add or change whatever he proposed in here tonight. Right? We can't be hearing something different than what is stated in here.
that's correct.
Okay.
So would 3 parking spaces in the back be a change that could be addressed?
Steve said you wouldn't need a variance if you had 3.
Okay.
Right.
Well, let's take a shot. See what happens.
So you would be happy with 3 then, right? If
Well-
this didn't go through?
Well, I pretty much outlined my views in writing.
Okay.
Want to get everything on paper.
We shouldn't really be discussing this off the record, but so let's just proceed with the case. Okay, case number 3, 06-13V for variance, 52 Columbia Avenue. The appellant is Gary Kerber, Zone R1. The appellant is requesting a variance from Section 23.11, Table B, Office Street Parking Requirements to permit conversion of a single-family resident to owner-occupied with rumors where 4 parking spaces are required and none are provided. Steve, you have more to say?
Hopefully, each of you have some information about this case. I think one of the first things to go back to the questions you'd ask about the relationship of the right-of-way to structures and where that might be located. I think this case is a very good example of that. If you would look at the drawing that shows the footprint of the house in relationship to the property line. It looks like this right here. This section of Columbia Avenue has a 60-foot right-of-way, and so there's quite a bit of distance from the curb line back to the structure. Although that distance, if it's used for parking, cannot be counted toward a parking requirement unless City Council grants a revocable license for that. We've had several properties in town that didn't have the required amount of parking when they were converted. And in several cases, City Council has granted a request to use the right-of-way for parking, and the board has never even heard those cases. So this drawing right here is a good example. You can see that the short distance of the driveway from what used to be the garage where it says concrete, that's the driveway. So the driveway surface is a lot longer than that out to the street. It's just that there's not enough, technically not enough room there to park a car.
What is the designation of owner occupied with rumors? What is that?
Yeah. In an R1 single-family zone or any other zone where residential use is permitted, there are three principally permitted uses of property. One is owner-occupied, so an owner can live there and their family. Those related by blood marriage or adoption. That's the first property right that you have in an R1 zone. The second property right that you have in an R1 zone is to rent a property to what's called a housekeeping unit. In an R1 zone, a housekeeping unit is a maximum of 3 persons, any one of which is unrelated by blood marriage or adoption. So that's your second use permitted by right in an R1 zone. Your third use permitted by right is to have an owner-occupied house and keep up to 2 roomers with you if you have the floor area and the parking for that. So we probably got, I think it's probably about 20 owner-occupied houses in town that also rent rooms out. So it's kind of like a mini rooming house. But again, an owner or which is just a single person, or it could be a family, is allowed to have up to 2 additional people unrelated to them living with them. Now, the catch with that is there has to be at least 2 parking spots provided for the family. Doesn't matter if it's a family of 10 or a family of 1.
Right.
2 parking spots required at a minimum. And then 1 for each additional roomer, for each additional occupant.
So we are talking about 2 roomers maximum here.
Right. Mr. Kerber had originally proposed that he be allowed to be permitted 2 roomers, and that's where I had initially refused it on needing 4 parking spaces, 2 for himself and 1 for each roomer, a total of 4. What I provided you tonight right before the meeting was a letter that I received several days ago from Mr. Kerber. He is now requesting that his occupancy or the number of roomers be reduced from 2 to 1. So that reduces the parking requirement from 4 to 3.
There's no restriction of having like a separate entrance for the roomers or family members or anything like that?
No, as a matter of fact, when you have a owner occupied with roomers, it can't be set up like a duplex. In other words, there has to be free passage. You can't wall it off, completely separate it. Now, there's no problem with adding, another study area for roomers or adding another restroom.
What you're saying is
bathroom.
that you can't make a duplex out of
Can't
it.
duplex it. And the definition generally entails the definition of a kitchen.
Okay.
And there's actually 4 different things that you have to have a kitchen. Lacking any one of those 4, cabinets, a sink with running water, a cooking device, and a refrigerator. One of those lacking, it's not really then a kitchen. So as it's been presented to me, Mr. Kerber's not proposing a duplex. He's just proposing 1 roomer to live with him in a separate area of the house. That's the accessibility is, there's cross accessibility.
Yeah, okay.
Another document that I provided you tonight that I had previously received, but after I delivered these packets to you, was a statement of opposition by residents of the neighborhood. It's a 3-page document that I provided to you. Mr. Kerber has also been provided a copy of this document, and you also got a copy of his request to reduce it from 2 down to 1. And I received correspondence from a neighbor across the street just this morning. She came to my office, and we also emailed back and forth. So there's written documentation of her concern about it. And again, this is a document that was just generated this morning because the owner at 51 Columbia was not able to attend tonight, but did want to express her opinion. So that's another piece of information I was just able to provide you just tonight.
Do we need to read these letters for the file, or just accept them as is?
You know, well, I'd say that's up to you. They are part of the record. I don't know that you necessarily
Okay.
have to read them into the record. If that was the case, you'd be reading every document that was submitted. It's been, these documents have all been in the case file and available to the public,
Okay.
you know, every day since the original application came in. Although, you know, be it some of them just at the last minute. I guess the only thing that has not been in there for quite a while is just this email correspondence from this morning with the neighbor across the street. And then she did come in and speak with me this morning, too.
Any questions for Steve?
No.
What, now this request came in after the construction had already been completed, when my office received an inquiry about an address assignment. And that's when we discovered that this renovation had taken place. There was no permit issued for the renovation. And Mr. Kerber then asked me what the possibility was, or how, was there a way that he could keep the use of this area of his house that he had started. And of course, the only way to do that is, for your first course of administrative relief, or your first action in due process, is to ask the board for a variance first. So that's why we're here tonight.
Okay.
And again, essentially what happened was Mr. Kerber converted his garage area to a small additional living area for, and at this time, he's requesting then just one room rather than two.
Okay. Thank you, Steve. I just want to mention that there is a letter from Mr. Kerber that does, dated May 8, that I would like to change the occupancy for the variance applied for 52 Columbia from 2% to 1%. So that's good. Okay, thank you. And
Then that would change the 4 parking spaces that we have here
Yes,
to 3
yeah.
parking spaces.
David, I want to put you on the spot. If you could summarize these 2 letters, you don't have to read the whole thing. I've been chairing 2 other meetings today, so if you could do that, please, so I can read some few documents.
Sure. We have an email from Kelly Piro, 51 Columbia Avenue, and I'll just read a selection from it. It says, I live directly across from 52 Columbia. I just found out last night that the BZA meeting is going to happen tonight. Due to the short notice, I was unable to attend. I want to voice my opposition to Mr. Kerber's request for a variance living on Columbia Avenue. Parking is often a challenge, even now. I feel if Mr. Kerber is granted more spaces, the problems I have with guest parking now will only increase. As it is, if someone on our street has friends or family over our street, is crowded with cars, typically when I have a guest over, they have to park way up the street or down the street. Like most houses on that street, I do not have a driveway. I have no other options for parking except the street. I feel that granting Mr. Kerber more parking spaces on the street will not only impact me, but others around us as well. So that's the email from the neighbor across the street. And then there's another letter signed by by 20 residents, all on Columbia, mostly on Columbia Avenue. I see one other address on Garfield. And it says, we, the undersigned, are residents of Columbia and Garfield Avenue, and we oppose the grant of the requested variance. It cannot legitimately be claimed that the issue is not of so general or recurrent in nature as to make reasonably practicable the formulation of a general regulation for the condition presented. There are many situations in the city where the number of on-site parking spaces required by the number of rental units contemplated is not possible. The Board of Zoning Appeals has repeatedly denied requests for variances in these situations. It should continue to do so. The City Council, in its wisdom, determined that in such situations, off-site parking would not be appropriate for rentals in R1 districts. The legislative determination should be respected. As a result of the same facts, that is there being many situations like this throughout the city in R1 districts, there are no circumstances which may be characterized as exceptional so as to meet the exceptional circumstances requirement for making the variance permissible. A grant of a variance here would clearly materially undermine the public interest. Applicant contends that during the time he has lived on Columbia Avenue, there has always been sufficient and adequate parking for homeowners. It is respectfully suggested that this is not always the case, but beyond that, although it must be admitted that the parking situation on Columbia is not what it currently is on Grosvenor Street, Congress Street, or Franklin Avenue, applicant miscalculates the effect of a decision in his favor here. A decision in his favor would be a precedent for the effect, or would be a precedent for like decisions, if not all over the city, at least on Columbia Avenue. If multiple houses on Columbia were given a similar variance, the parking situation on Columbia would approach the situation on Grosvenor, Congress, and Franklin. The point, of course, relates back to the point that the applicant should seek relief through the City Council, not this board. Finally, there is no question that the preservation of equal property rights, the property at 52 Columbia Avenue may be used as may any other property similarly situated. And it's signed 20 names, and this is in the record.
Thank you, David. Mr. Kerber, would you like to come to the podium and state your name and address and your case, please?
Hi, my name's Gary Kerber, and I live at 52 Columbia Avenue. I have not made any changes to the footprint of my home. What I would like to have is just one additional person living with me. That was my goal to begin with. I put my points in writing, and I like to give that to the board right now. And I've got copies for the people here in the audience. If you have any questions.
You're relying on off-street parking for all your parking at this point in time?
Well, there is one parking space in the right-of-way that has 17 feet. It's 17 by 10 to the sidewalk. There is also, two houses down, she has one parking space, and it's only 15.6 by 8. And I found a document when this property was a rental, and it had 2 parking spaces listed before it was converted over to an owner property. So I would like to have that grandfathered in if that's possible. I don't know if that's possible. But the other option is that I could tear down part of my house and 1 foot and put a parking space in there so I can have 3 parking spaces. I have always parked on the street, which most people on Columbia Avenue do. And I really have never had any problems with getting to my residence.
What you're saying is that most of your neighbors rely on on-street parking, the same as you do, so on-street parking would be at a premium.
Well, yeah, but my house is situated between 2 lots, and there's like 5 residents over a 225 linear feet of street parking, minus 3 curb cuts for a driveway. That's 195 linear feet. And there's also 7 off-street parking places within those 5 residences. So that's like 17 parking spaces that's available. Now, if everyone who lived in those 5 places had 3 people, 3 cars, that's 15 parking spaces to fill that space. And I've never had any problems getting to my house. I think twice in 3 years, and that's the truth.
Mr. Kerber, you are just the only person in that house right now?
That's correct.
You only have 1 car.
Yeah.
And let's say the worst scenario, you sell your house and
Mhm.
the family moves in and they require two spaces, right? Minimum. But let's say that family could be 5, 6 people in it and they could have 5, 6 cars, and then if we grant the variance, it's gonna go forever with the property. So that's what we have to consider in the future, what's gonna happen. You know, right now it might be okay, but we need to consider for the future, the worst scenario, how many cars is gonna be there.
Well, if you've been on Columbia, there's a lot of garages that are used for storage. They don't use them for parking, at least on the south side. On the north side, the parking is better. They have off-street garages, except for the neighbor across who only has 1 parking space. And I've never complained about anybody parking in front of my house, and I don't know of anybody else that it affects. But I talked to all 3 of my neighbors that it would affect, and 1 doesn't mind, 1 is against the lotting of the variance, and 1, when we talked, was kind of neutral. So I tried to talk to the people involved.
When you remodeled your garage, you weren't aware of the fact that you needed a building permit?
Oh, I just got ahead of myself.
Any questions? Great, I guess not. Thank you. You'll have a chance to come back for rebuttal.
Okay, can I give you this document?
Sure, absolutely.
Thank you.
Is there anyone who would like to speak on behalf of the appellant in general comments or opposition? Opposition. Opposition, okay. Please state your name and address for the record.
My name is Bill Safranek, 34 Grosvenor Street. When this matter was originally scheduled, I didn't plan to speak, but notice has been short, and I submit that that's kept down the number of people who are appearing here to speak, and so I took it upon myself to come. And I did prepare this document, so that gives me some insight into what's going on. The board has read the document into the record. I won't do that, but if I could, because I think it does address the legal points with some precision. So I'd like to make some comment upon the document, not boring the board with reading it. I really submit that the biggest point is the first one. It just cannot be claimed that this kind of issue is not of a general or recurrent nature. It comes up all the time. This board knows this kind of issue comes up all the time. Within my, memory, dealing with cases that are in sort of my general neighborhood, and I sort of come as I'm not up on Columbia, but I am of the general neighborhood, sort of the Anna neighborhood. There's been one on, there was one on Grosvenor that we came and opposed. One the same night on Congress. There was another one on Grosvenor that the appellant had the good sense to see that he wasn't going to win and pulled it. That was 150 Congress. The first one was 108 Congress. The second one was, and the number gets away from me, the one on Congress. But there was 108 Grosvenor and then 150 Grosvenor that was pulled. And at the same time, same day that 108 Grosvenor came up, there was one on Congress. I'm going to guess 135, but that's gotten away from me. It comes up all the time. If somebody wants a change of this sort, their course is to go to city council and see if they can get the change. About the, most of these are just hard-nosed legal issues. But the question about materially undermine the public interest, I mean, either they're made or they're not made. But, I submit the fact that there's so many people that actually signed this is some measure of the public interest. And I do want to emphasize in that connection the point that the appellant miscalculates the effect of a decision in his favor in this case. Because the decision in his favor in this case isn't just going to, come on, his case is going to be cited again and again and again by other residents of Columbia. And, the letter from, which Kelly Perro takes issue with Mr. Kerber's assessment of the parking situation on Columbia. But be that as it may be, assume he's right, keeping in mind that her letter very much takes issue with what he has to say. If he gets what he wants, then the next person on Columbia comes in, and the next and the next, and believe me, you're going to be down to the situation that you've got on Grosvenor, on Congress, on Franklin. It's going to be the same before you know it. Finally, I think that legal issues are more than enough to say no to this request for a variance. But in my conversation with Mr. Pearson, I think yesterday, it came to my attention. I'm not sure whether you were alluding to the same thing or not. But as I understand it, the construction was at least begun, if not completed, before there was a building permit, and the people were moved in. And that's a real equitable consideration here. I mean, this is not the situation. Ms. Hanson here, the chair asked the question, had you moved people in? Yes, she had, but there was another section of the code that allowed her to do that. She was not in violation of the law. That's not the situation with Mr. Kerber. He's in violation of the law. I submit that on all the considerations, legal, equitable, anything, this is not a variance that this board should grant. Any questions?
Okay. Yeah. Were you aware before tonight that he had requested to just have only one person, roomer, in the place?
I was aware before tonight. I think I was aware yesterday.
Okay.
I'm not sure. Yeah. In fact, maybe we have a conversation. I can't.
I think you'd ask people, I wasn't in the office, and Mr. Sopranik, in general, is there all the time asking cases that he has interest in if there's new information in the record. So we corresponded and shared documents on this over the course probably of a month.
I'd like to know
I'm
if
not sure.
those people who have signed, did they know that this was changed from 2 to 1 roomer?
No.
Okay.
The signatures are,
But
most of them are dated May 6th, and the request for the change is May 8th.
Okay, May 8th, okay.
But what are they going to do? I mean, that's not generally communicated to them.
Right.
They present their ups, and would it really make a difference to them? Because if you look at the cumulative effect that a variance, the variance is granted. Now you say, well, he's parking on the street himself anyway. And so you're really adding only one, But it's not just the only one because of the effect of the precedent that's been being granted. It's one and another and another and another. And it just goes on and on. So, I submit that it matters. And, there's a rule. The city council, in its wisdom, has passed this rule. If Mr. Kerber wants to change it, he should go to city council. I think Dr. Elam would like to speak.
Okay, thank you, sir. Any questions? Anyone else who would like to speak in opposition? Yes, sir. Please just state your name and address.
My name's Dr. David Eland. I'm a resident at 61 Columbia Avenue. My wife and my signature are on the vote of opposition with regard to this. We've lived on Columbia Avenue now for approximately 10 plus years, 10 and a half years. It's been our experience that at times there is significant difficulty in finding parking places there if we don't have the opportunity to park in our own driveway. The people on the north side of Columbia Avenue don't have any parking spaces. They have to rely on what's available on the south side of Columbia Avenue. As such, that means that those parking spaces there are not just for the people on the south side that happen to park there, but for those people on the north who also may have guests. As Ms. Perot noted, she has a garage that has room for her car. There isn't enough driveway for a guest to park in, so that individual ends up having to park on the street. So we're opposed to this kind of a variance because of congestion, and we also have some consideration and concern about property values when you start doing these kinds of things. There's been a lot of work done, at least in the time that we've been here, to fix up the street. We've done a lot of work ourselves to make it look nicer, to bring it up. Now, in Mr. Kerber's case, he's done some very nice yard work in the front of his house, and that's very much appreciated. But putting 4 parking spaces into that very small footprint in the property cannot do anything positive for Columbia Avenue, and that's our opinion. On short notice, we were the only residents who could come, and it was rather inconvenient for us as well. I have a very sick daughter at home.
Any questions?
Do you feel that it would make any difference to any of your neighbors? Because I'm asking you to speculate.
Sure.
That he's scaled back the request?
You know, I think that would best be asked of the neighbors. I hate to speak for them.
So what is your opinion? I mean, just your own.
I would have to see how it was going to be implemented before I'd have an opinion. I would be opposed to 3 parking spaces in the front of the house, most definitely. I can tell you that for sure.
Okay. Thank you, sir. Anyone else in opposition? Mr. Kerber, you have a rebuttal chance.
To begin with, Mr. England owns 2 other properties right next to his residence, and I would like him to answer how many off-street parking spaces those both rentals have. And secondly, because I know I would say there's 2 apiece, and they're not even close to my residence. And when they do park, they park next door, you know, when they do have a meeting or a gathering. It was never, ever my intention to put parking spaces in the front yard. When this variant, or when the petition was being generated, I heard from a neighbor that they were using that as a way to get opposition. I mean, if you look at my front yard, there's been tons of work put in there. You know, why would I, you know, so there was a lot of assumptions and promotion of this idea that I was going to tear down, you know, put 2 parking spaces in the front yard. No one talked to me. No one asked my opinion. I have the other option of using the rear alley to put 2 parking spaces. It would look terrible in the neighborhood. I agree. You know, I don't want to do that. I don't want the neighborhood to be detrimental, you know. And I just want the one parking space to be that's there, that was there previously when it was a rental, before it was turned over to an owner property, to be considered one parking space. I do have some reservations about this petition, and I think I noted that in the paperwork I gave you. I mean, there is 27 houses on the direct block. That counts the houses on North Congress, or North Columbia. But I want to back up first, okay? So the only person who has 1 parking space on the north side of Columbia is Miss Peru. And that's out of 5 houses. Everyone else has double parking, off-street parking. She is the only one who generates a need for on-street parking. Okay. Columbia has 20, the block that if you look at the map, considering North Columbia, the houses on South Columbia, the houses on this side of Garfield, and the 2 houses on Highland, there's 27 houses. 12 of those are rentals. And I broke that down for you. I mean, there's people who applied for variances, have been accepted for variances, that there were 2 people or 3 people on that petition who were appellants and were granted variances for their property, but they're objecting to, you know, my variance, you know, which is minimum to me. So that reduces the signatures, I would think, and they got renters. Two of Mr. Eland's renters signed that. And so it really diminishes how many addresses are addressing this petition. I don't think there's that much support as they put on. You know, where's the other 9 residents? If everyone was so adamantly against me having 1 person living in my space, where are they? I mean,
Has anyone advised you, or were you aware that you could possibly find lease a place within 500 feet from your residence so you can park a car, or
I heard the idea. I haven't,
you haven't
acted
pursued
on
it?
it, or and you know, the option is to put the parking in the back. And
Yeah.
I mean, if my hands are forced, what other option do I have? It just doesn't make sense.
Why do you appear to be reluctant to create parking back there? Could you tell me why?
Well, I'm a landscaper, and I put tons of work into my place. You know, and as far as property value, I put new windows, new siding, fixed up the back, fixed up the front, put a new rock wall in. The only thing I've done was add to the values of the property.
See, you also have to prove to us what your hardship is. You know, what is the hardship that we need to consider? What is the special circumstances, you know, that we need to consider? You
Well,
need to
there's
prove that to
nothing
us.
other than personal, but that can't be accepted here.
Well, you know, with a reason, we probably can consider it, but you need to state that. What is the hardship that you cannot use this property as it is with 1 person, you know? Or you don't want to provide the parking?
Well,
as
the
well, you said.
hardship is not, you know, it's like owner's rights, you know? I mean, I've got a house, 1,900 square feet. Why do I need to live 1 person in a house of 1,900 square feet? I mean, I know of other people on the, you know, in the neighborhood.
Well, according to code, you cannot, and that's why we are here. We need
Yeah.
to hear 6, go through the findings and determine that, yes, you have the hardship, there's special circumstances, and then maybe we can grant that, but we need to hear that from you.
Okay, the hardship is I have right now I'm on 5 medications, so that's a personal hardship. I have pain issues, and other than that, I don't want to go into my personal.
Right, I mean, it seems like it may be financial hardship, is that what it is?
Well, yeah, I won't have the house paid off until I'm 73.
Yeah,
This is my-
unfortunately, we cannot
I know.
consider
I know that.
financial
I
hardship.
know. But anyhow, you know, this is my attempt to try to retire before I'm dead.
Okay,
So that's why I did it.
thank you, sir. Steve, you had a comment?
I'd like to clarify a couple things. First thing was, Mr. Kerber alluded to a previously issued rental permit for 52 Columbia that indicated there were 2 parking spots. That permit was issued prior to the time parking was even an issue. At the time, parking requirement was 1.5 per unit. In other words, you could have 1.5 parking spots required for 5 people in a rental. Council it's a 1997 ordinance, adopted in 1998 is the ordinance that created this higher requirement for conversion. Since 1998, all the rental permits have been updated to reflect the number of parking spots that are actually on the lot, and not, say, partially on the lot and the right-of-way or all on the right-of-way. So any permit in the office prior to 1998, that number really didn't mean anything because there was no, it wasn't a requirement. So a code officer looked there and he did see a distance from the sidewalk to the face of the garage. It looked like a car could park there, and then a car in the garage. That's why there's an indication of 2. But as on the drawings is indicated, and Mr. Kerber's asked for some relief related to a grandfathering for that parking spot. That's not possible. Only city council has done it. If, say, for example, he needs 3 parking spots, the only way that the one from the sidewalk to the face of what was formerly the garage could be counted would be for city council to grant a revocable license for use of the right-of-way for parking. That is a possibility. Just on the other side of the alley that Mr. Kerber's alluding to is 15 Garfield. I don't know if you recall the 15 Garfield place that came back and forth to the board over a period of about 2 years.
Yep.
Parking in front, in the right-of-way, in lieu of parking on the lot, city council, they didn't deny the request, they just never acted on it. And just so you know, too, what the people at 15 Garfield did was they proposed a parking lot off the same alley, which met the requirement. And I was in the process of issuing a permit in order to allow the conversion to rental because they were installing the right amount of parking spaces, and it caused quite an upheaval in the neighborhood, I think, as Mr. Kerber had alluded to. Eventually, at 15 Garfield, they just poked the back end out of their driveway. In an R1 zone, you can stack park, and that's how they come up with the requirement. But there is a public alley there that, that could be used to access parking, as Mr. Kerber alluded to. But he would have to have 3 parking spaces back there, not 2, plus there's no grandfathering for the one in the front. It'd take a revocable license of council to allow that to count as 1 space. Mr. Gold, you'd said something about 2 spaces would be required if a family moved back in. There's no requirement, there's no parking requirement for existing residential structures. If they go from rental back to owner occupied, if they have no parking, there's no parking requirement. That owner occupied requirement is only for new construction. If that were the case, there's a lot of places in town with no parking, and we'd have a line out the door hearing that many cases. So there is no law related to that converting from rental back to owner occupied. There was some allusion to the possibility of leasing off-site parking. The board has considered that on occasion, but when it's in some proximity to a zone where parking lots are permitted. In R1 and R2 zones, parking on a lot is for the exclusive use of the resident. So if you recall, that was the same situation, I think, Mr. Safranek alluded to up on Congress, because in that case, the neighbors had talked to the lady next door. There was an alley that went down to a garage that she didn't use, and that was another one of the variances that was required on that property to allow parking off-site in a zone where parking was only permitted for the exclusive use of the resident. So there's really no, the ability to lease parking would be somewhere down on Columbus Road.
Yeah, okay.
Or, boy, let's see, further down the street at the intersection of Lancaster and Second. Well, actually, it's Second, Lancaster, Columbus Road. There's a lot of things going on at that intersection. So just those 4 comments. One about the number of parking spots, one about parking required for owner occupancy, revocable license, and the leasing issue.
Okay, thank you, Steve. Mr. Kerber, any final comments you have?
I plan on
Okay.
getting a revocable license.
Yeah, okay. Thank you, sir. Discussion from the floor is closed. Any discussion from the board members? Greg? I would appreciate maybe a motion from one of you two gentlemen.
I move we grant a variance in case number 06-13V, Zone R1, located at 52 Columbia Avenue. Gary Kerber is the appellant. The appellant is requesting a variance from Section 23.11, Table B, off-street parking requirements to permit conversion of a single-family residence to owner-occupied with roomers where 3 parking spaces are required and none are provided.
Second?
Okay. Practical difficulty or undue hardship. There must exist a practical difficulty or undue hardship caused by exceptional conditions pertaining to the specific piece of the property.
That's a tough one.
I'm sorry, we can't hear you anymore. I guess the property could be utilized as is for a number of occupancies. And number 2, exceptional circumstances. There must exist exceptional circumstances or conditions applying to the property or its intended use that do not in general apply to the properties in the same zoning district. Roger?
It's not unlike the other houses on the street. It is now that the garage has been converted.
Is there any exceptional circumstances to this property that does not in general apply to the properties in the same zoning district
None of that?
that would require this variance?
Can't think of any.
Preservation of equal property rights. It must be determined that the literal interpretation of the code would deprive the appellant of rights commonly enjoyed by others in the same vicinity, while granting the variance would not convey any special privilege. It appears to me that maybe we will be granting some additional rights to this property than is commonly enjoyed by the others if we grant the variance. Agree?
Right.
Do not agree?
Renting out rooms to roomers is.
Everybody done it up through there, we'd be in good shape.
Pardon me?
Everyone on that street did that, we'd be in good shape.
Minimum variance. It must be determined that the variance is the minimum required to make possible the reasonable use of the property. The key is the reasonable use of the property.
being an owner-occupied property without any renters is or without any roomers is reasonable use, then it can't meet that standard.
Number 5, absence of detriment. It must be determined that granting of the variance will not be of substantial detriment to the adjacent properties, nor impair the principles of the code. Well, we do have some petition from the neighbors that apparently think so, although they were not aware of the fact that the variance was not more minimal than it is now.
Parking in that area is
It
at a
is.
premium.
It's, yeah, it is, yeah, it's premium, yeah. Not of a general nature, the variance sought must not be of a general or recurrent nature such that the situation would more reasonably be handled by the changing the law. I don't think that would apply. Greg says no.
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 And I would know as well. Sorry. And I guess we are moving around fine. Case number 4. Case number 06-15S. What does S stands for?
Substitution and non-conforming use.
Okay. Property of 18 and 18.5 Palmer Street. Appellant Anthony Farian. We don't have any
I think he
note.
went to John. He'll be right.
He's off feeding the parking meter. He told me that he parked in a private lot that had
Okay.
meters, and he was afraid that his vehicle
Oh,
might get
corn
towed.
melts, yeah, they'll nail him.
So he was
Okay.
gonna run
Should we
across
take
the
about a
street.
few minutes break?
I think so. Probably
Okay.
good to adjourn the
We'll
meeting
take
for
about a break till he shows
just
up.
a moment.
Well, the nice thing about that last case, even for his 5, it's still been voted down, so.
No, I don't know. We'll just have a motion to take a break here for a second and wait for
Yeah, we'll
time.
take about
That way
5
they-
minutes break.
I got locked out.
You got what?
Really?
Yeah, I was downstairs. I couldn't get back in the building.
Oh, they-
I apologize. I stood and waited. Oh,
Well, we'll give you a couple of minutes to cool off a little bit. And then,
well, I'm ready. I appreciate you waiting. I thought, wow, will somebody recognize I'm locked out? I, no, it didn't get towed. I'd be standing down there. Oh, God. Okay.
You can have a seat for a second. I'll
Yeah.
start
Okay.
the presentation.
I didn't realize it's in the clock.
You ever do that at home? Or do you have a key hid somewhere outside?
Yeah.
So, is this from the new comprehensive plan?
Yes.
so maybe I will read the case and then, this is case number 06-15S, 18 and 18.5 Palmer Street. Appellant Anthony Farian. Appellant is requesting a substitution of a non-conforming use, 2 principal structures on 1 lot with a total of 5 tenants, where a maximum of 1 principal structure is permitted. For a not more objectionable use, which is 2 structures with a total of 13 tenants. Please, maybe you can.
Sure. At the beginning of the
Explain
meeting,
the
when
whole-
you read through the jurisdiction of the board, the first thing normally that the board does is consider requests for variances, but you also consider temporary use, substitution of non-conforming use, and appeals where the decision of the zoning inspector is in question. So this is in one of those kind of off categories, substitution of non-conforming use. I think the last case you heard like this was down on Foster Place. Greg Chapman had 2 houses down there that didn't have very much parking at all, and you allowed him to substitute the construction of a brand new building for the demolition of these 2 smaller, approximately 120, 130-year-old structure. So that's the last time the board's heard one of these substitution type cases. There's a possibility of looking at this in two different ways, and I'd first, in Mr. Chapman's case, said that I thought it required a variance, but he did then, and are looking at the ordinance, it did look like the board could consider situations like this as substitutions of nonconforming use. The existing nonconformity is the number of dwellings on the lot. There's a house in the front, a single-family home, occupancy right now of, I believe it's three tenants in the front house. There's a garage in the back that has a grandfathered garage apartment or a second residential structure. So that's the existing nonconformity. The occupancy there is for 2 people. Mr. Farian would like to essentially demolish that existing building, reconstruct the building in essentially the exact same footprint, same size. It's essentially a 2-story building now with parking underneath and residential use on the second floor. So the issue is the 2 buildings on the lot. There's no problem with parking. There's a larger drawing there that Mr. Farian's illustrated. He owns 3 properties right in a row.
Yeah, 4 properties. Right?
4 properties right in a row. And parking is not a problem. Parking can be deed restricted. This is an R3 zone, and parking can be deed restricted so long as it's in an R3 or higher, same ownership and within 250 feet. So the parking here is not an issue. There'll be no need to expand any of the existing parking area. The question, though, is increasing the occupancy from 2 to, I believe what he's requesting is 10 people in this newly constructed building. So basically nothing's going to change except one building is going to get substituted for almost exactly the same size building. The big question is it all right to go from 2 tenants up to a total of 10 or an increase in 8? Substitution of nonconforming use also, and I'll check it in here. You don't have to go through any findings. I think the only thing that you have to find is that it's a not more objectionable use. Included in the packet, and I did talk to Mr. Farian when he did come in, the information I provided to you has some sections, excerpts from the draft city comprehensive plan that address residential use in the Mill Palmer Street area. It has been identified as an area that could possibly have increased densities, increased numbers of persons. The draft comprehensive plan actually says that that type of area and other areas similarly situated should be categorized by a different zoning category, R4, which would be a higher density requirement. Now, that's just a draft plan. It's been accepted by council from the main committee group that worked through its creation with Pogemeyer and Associates from Bowling Green, Ohio. The Planning Commission is about to send their review of it back to City Council. That's going to happen just in the next few weeks. So, but I just wanted to give you an idea about the direction, at least that the draft comprehensive plan is looking at in this particular area.
Steve, did you say 10 or 13? This says 13 tenants in here, but you.
Well, that would be 10 in the back building, 3 in the front building.
Okay.
So the front building occupancy won't change. It'll stay at 3. The back building will go from 2 to 10. So the total will be 13, where the total now is only 5.
Okay.
Front building's not changing. Parking's
Okay.
not changing.
All right, so one building is gonna stay as is.
Right.
One is gonna be demolished and then rebuilt.
Correct.
Okay, thanks.
Now, included in your considerations for a not more objectionable use, there are setbacks also that are non-conforming. But the reason that I didn't even, I'm just mentioning them now because the back of that building is not 40 feet away from Landmark. But it's not more objectionable what he's requesting. But I did want to bring it to your attention that the back of the existing building is right just about on the property line. Well, it's not Landmark now. It's proposed to have new residential construction at the site. The most current developers kind of dropped out, but at the Planning Commission meeting on June 1st, the owners, Hayes and Cornwell, will be at the Planning Commission with a new proposal for the development of the area just adjacent to this or just to the west of it.
And why wouldn't this be a variance case?
There is an existing non-conforming use, 2 buildings on 1 lot.
He's not going to change it.
Yeah. The standard, if you ask for a variance, you'd have to go through the findings. How can you, I mean, it'd be a special privilege to have.
If he wasn't changing the building, just keep him as is and want to increase the number of tenants, he had to get a variance, right? For parking, for other stuff?
No parking
No
variance.
parking is required.
Parking's not a question in this particular case. There's plenty
So
of parking.
if he
there.
wasn't changing the footprint or changing the building, he could have bring more people in then, right? Without the variance?
That's correct.
Okay.
But what we had looked at, and the thing we'd considered too, non-conforming buildings can only be improved no greater than 65% of the county auditor's value assessed or value determined. And we figured that, calculated that to be just about $35,000. So Mr. Farian could improve that property and increase the occupancy with restriction for the parking up to $35,000. The building's also located in a special flood hazard area. Those regulations say that a non-conforming building, which this is, the first floor is below the base flood elevation, can only be improved 50% of the market value of the building. Again, we took auditor's values and made some calculations based on market value being a little higher than the auditor's value. It still didn't come out, it was still below $40,000. One of the benefits of this reconstruction as far as flood damage prevention is concerned, the new construction will have to be flood proofed or flood compliant. So that first floor, new construction, will have to be at the base flood elevation plus 1 foot. So, you know, that's just a, floodplain is an overlay district, has different requirements. As I mentioned, zoning code, 65% improvement to non-conforming. The overlay zone, flood hazard area, 50% improvement. And those numbers just didn't seem reasonable to take a building in that condition and just, I wouldn't necessarily describe it as Band-Aid it to, you know, to just increase the occupancy. What I was looking at and what Tony and I had discussed too was that a brand new flood compliant building would you know, with a approval for a substitution of a non-conforming use would probably be better than a $35,000 renovation of a converted garage. So hopefully that adds a little more detail as to how we got to the point where there was a decision, it was going to be a substitution or a request for a variance.
So is this building that's there, would you describe it as being substandard? The building that's going to be replaced?
It's substandard as relates to the flood damage prevention ordinance. That could be remedied by just putting in some vents in the walls. Structurally speaking, to be real honest with you, I have not done an inspection of the actual building itself to say that, you know, $35,000 wouldn't do it to be able to remodel it and put that many people in there. Let's see, let's go back a little bit. Mr. Farian asked for a substitution of a non-conforming use at the property right next door about, 3 or 4 years ago. Same situation at 16 and a half Palmer. I know that that building was in, as Tony got into it, his original intent was just to do as much necessary to stabilize the building before he actually started the renovations to it, and it ended up, the thing just started, once he touched it, it's just started falling apart. So what appeared to be a fairly structurally sound building just started,
Well, it's been
turning
my
into
experience
pieces.
that new construction is superior to remodeling in almost every instance, not all, certainly most instances.
Yeah. The, and again, you may see some things around town where it looks like a building has almost totally hit the ground, and you've never, there's no request for anything like this. And again, usually that has to do with some nonconformity of the building, where that 65% improvement is the threshold for having to come in and speak to the board. If you can keep those numbers below 65%, that's why you see some of these buildings that look like they should have gone ahead and hit the ground, end up being reconstructed. And in a lot of cases, I think the people that do that wish they would have gone through the process and just started from scratch and asked for a couple variances.
David, any question?
If he were to wait for the R4 zone to be created and for the neighborhood to be rezoned,
Mhm.
assuming that happens, would he need to request a variance or a substitution?
Right, we'd still have the same situation, because if you have 2 or more residential structures on a lot, right now that's described as a planned unit development. So I suppose if you really wanted to spin it hard, these two structures on one lot, by definition, are a planned unit development, just like University Commons is, or University Courtyard, or River's Edge. Because once you get to 2 buildings, then you're a planned unit development. That's not going to change. The draft comprehensive plan talks about planned unit developments, multiple buildings, but developing larger areas, reclaiming larger areas, like the landmark site, like the Bob's IGA site. It doesn't really narrow itself down to multiple building, one lot development. It does, in some aspects, address multiple units in single structures. So again, the key to why we're here and looking at it as a non-conforming use is because we have 2 buildings. Mr. Farian could tear down that building in the back and build an addition on the front house, so long as he didn't encroach in any of the yard requirements, go over the height requirement or the lot coverage requirement, and not encroach into the rear yard requirement. He could just add on to the back of that house, and I think in that area, you've seen development of that nature.
A lot of people have done that.
A lot of people have been able to come in and get an approved permit to renovate structures in just that manner.
We've given variances for that.
There's a lot of them down there that just straight out got permits by right, and even though they were able to do that, it may not have been the most positive thing for the area. It may not have been the most efficient construction technique, but it did accomplish what those people wanted to do, which was have as many people on that property as they could, but not have to come to the Board of Zoning Appeals. So, in that respect, I think Mr. Farian's being right up front with us here. He could do the same thing on Palmer Street that quite a few people have done, tear that building down the back and add on to that house in the front. That was a single-family home. Mr. and Mrs. Fee lived there. I met them when I first came here. That was his wife's family home when there were families on Palmer Street. And there were families that lived on Palmer, but I don't think you could identify any of those houses now as ever being owner-occupied. This front house actually looks like it could be somebody's home. So, or it could look like the other houses in that area with those huge additions on the back.
Any questions? Well, thank you, Steve.
You're welcome. I'm sorry about that long.
No, that's fine.
Protracted
That was
explanation,
very
but-
helpful, thank you. Mr. Farian, would you please come to the podium and state your name and address? Thank you.
My name is Anthony Farian. I live at 8800 Lavelle Road, and that's in Athens. Steve pretty much elaborated on, most of the things that I would like to touch upon. you know, being the biggest of what Steve said, that I could, you know, without coming to you guys, I could tear down the building and add on to the existing home. But I don't think that that would lead to the consistency of the neighborhood, you know, and the way the home looks. It's a nice house the way it is, like Steve elaborated. It's a family, more like a family home than actually a student home. So basically me taking and, you know, reclaiming and putting a new building in the back where the old existing building is I think that's, you know, gonna remain with the consistency of the neighborhood as per se where the building is at, as opposed to adding on to the existing front building. I think it'll look better. As far as, you know, what Steve and I looked at and renovating the old building, and he touched upon the numbers, and, you know, certainly I could Band-Aid the existing building in the back and, you know, obtain my objective of getting more students into there. I would rather not do that because, yeah, you know, it just wouldn't look as good. The homes that I am in, the homes that I have right now over there, I'm sorry, thought I had that off. The homes that I have over there now, I have re-sided all of them and concrete parking lot and made everything look nice over there. So, except for this one garage apartment that I have. And, you know, tearing it down and making it look good like the rest of the buildings, I think would be, you know, look better for the neighborhood. Recently, local delegates paid handsomely for the comprehensive plan, in which has been scrupulously covered in the local newspaper and recently praised for its thorough research and overall professionalism. This comprehensive plan was created with the help of several local council and planning commission members. Among others, the C Plan addressed several key developmental issues for the city of Athens poised for growth. One issue in particular concentrated on the housing of the student population and an area defined as the Mill Street neighborhood, which contains the location of this proposed on Palmer Street. There are several suggestions and points of the discussion outlined in the C Plan, which I intend to touch upon here in my proposal. Since the city has invested so many resources into this C Plan, I will put great emphasis on its content to be used as reference here. The proposal of this project is to perform a substitution for the current structure at 18.5 Palmer Street under section 23.075.02 of the Athens Revised Code. The overall dimensions of the current structure follow a 42 by 32 footprint. The overall dimension of the proposed structure will follow a 40 by 30 footprint, much smaller and identical to the one beside it. It will be a two-story residential duplex that will accommodate roughly 10 residents in total. Since I own the properties located at 16, 18, 20, and 22 Palmer Street, parking for all current proposed residents will be no problem, as indicated in my attached drawings. According to Chapter Neighborhood Development of the C Plan, the land in the Mill Street neighborhood is predominantly multifamily housing with buildings and conditions categorized as marginal to average. It's a neighborhood conveniently located for students living off campus with excellent circulation. The C Plan continues by stating that this region is targeted for intensive redevelopment where a higher density of residential development is encouraged all over the location, essentially keeping the students in one area as opposed to other areas such as, you know, over off of Morris Avenue, and, you know, trying to keep these as more family housing and trying to define a more area for the students. The C Plan calls for residential density of 30 units per acre in an area where 1450 foot is considered high density. I am only proposing about 18.5 units per acre in an area consisting of 2,312 foot, slightly more than half of the C Plan's density recommendations and an excess of square footage. So we can only conclude that by granting of this substitution is in accord with the general purpose and intent of the code for the zone in which the property is located. The granting of this substitution will not be detrimental to the locale, but will attain the highest and best use for the property by inserting a brand-new multifamily home comparable to those around it. These circumstances already apply to this vicinity because the proposed building will be identical to the adjacent building in every manner, which you happily approved only a few years in the past. These are the same building plans. Let's see here. Currently, the two structures look unbalanced. Substituting this old building with a mirror image of the structure to the south will create uniform curb appeal and help improve the buffer between the residential zone on Palmer and the commercial zone to the west at the old landmark. The granting of this substitution will not substantially increase congestion on public streets because it creates more off-street parking in a district that already has enhanced pedestrian and traffic circulation. Public safety should increase with the replacement of a deteriorating building with a brand new one and by assembling more of the students into an enclave that best suits their needs. There are no special privileges being conferred to me here, as I've already done this before, and wish to follow the same course of action this time around. In conclusion, with the support of the comprehensive plan in accordance with the Athens Revised Code Section 23.075.02, I propose to substitute the current structure located on 18.5 Palmer Street with the identical structure to that which is located at 16.5 Palmer Street, as I've indicated in my drawings and on the tax card. I am proposing a higher density residential development in a neighborhood where this is encouraged, word for word by the comprehensive plan. I am only trying to accomplish the goals outlined in the comprehensive plan within the Athens Code office requirements to achieve the highest and best use for this property. I tried to do my homework.
Thanks for reading it, because I wasn't.
So,
Couldn't think about it either.
would you describe the building that you plan to tear down as being substandard?
Yes.
So we're going to replace a substandard building with a new one.
Yes, sir.
Good.
David.
Well, I was reading along with you, and you skipped over a section in the second to last paragraph that's pretty strongly worded, and I was just kind of wondering who this was worded, what this was meant for.
I also realize that the comprehensive plan has not been adopted, as Steve, so I felt that at this time that probably didn't best suit what I'm trying to say.
Okay, thanks.
Okay.
What we're going to be discussing after you sit down is that if this is more objectionable use than what presently is. And your thoughts on that?
I'm sorry, say that again?
Is this new your proposal, is it more objectionable use than what it is now? This is what we have to discuss. We have to see if your proposal is more objectionable.
Define objectionable. I'm trying to understand what you're trying to say.
Well, Steve, you want to maybe define exactly what the objectionable is. I can say.
Are you going to create problems? Are there going to be parking problems? Are there going to be problems associated with what you're going to do?
I don't think that I have plenty of parking over there. And, as stated before, I could tear the building down and add to the existing building.
You say you have plenty of parking.
Yes, sir.
In the other properties. Don't these other properties need parking also? I mean.
Well, if you've been by the property, pretty much all through the back, I've concreted that whole area.
Okay.
And
but they have their own people in the other buildings, the other houses.
Right.
So you can't just be counting on the parking on the other properties that you have within this property. So I don't have any number for how many other people are in the other properties and how many parking there is, but we have to look at it collectively, how many people there are and how many parking there is.
Right. If you look at the area back there, it's almost like a parking lot, the way it is back there, To say that people on 22 Palmer, when they go back there, aren't parked over behind 18 Palmer Street, people at 16 Palmer Street maybe parked behind 20 Palmer Street, it's pretty much a collection.
You've got so much parking that you don't even have to assign it.
That's correct.
And that's a pretty good thing.
Yeah.
People in 22, for example. How many people live in 22?
5 people.
How many parking spots there?
Oh, I think that,
15?
yeah, that property has an adequate amount of parking over there.
One of the things I'll have to check is to make sure that there's at least one parking spot for each person that lives on all those properties.
Okay.
There may be the necessity to have some deed restriction. The code does allow that. So if there's additional parking that's required at 18 and 18 and a half, it's available at 22. Mr. Farian will have to deed restrict it.
Right.
On the deed of 22, dedicated to specific use at 18, 18 and a half.
Okay.
That way, if he sells them off separately, that parking is restricted at 22 and can always be used at 18.
Excellent.
It's going to go with the property, not the owner.
Can we add this to the,
I'll check that.
can we add what you just said to the motion?
Yes, I had planned on deed restricting the parking as outlined, with the Athens city codes.
Okay.
If this proposal goes through,
Right,
yeah.
you'd say, and the parking verified to be in compliance.
Okay.
Right. Basically what I'm trying to get away from is if you go down there and you look where people have added on to the backs of these houses, I think that really takes away from, what a house looks like. So basically, instead of tearing one down and adding this on to the back of another,
Right.
I'm trying to continue with the look of what it is already. And, personally, I think that looks okay, as opposed to tearing it down and adding it on to the back, which I think would create, not look as good.
Right. Okay.
And I can do a nicer job, replacing the old building with a new one.
Okay.
It's on your sketch. It says 21 parking spaces on this lot. This lot meaning 18 and 18 and a half Palmer.
Yeah. In this particular lot right here, there's 21, and over here there's 20.
So
you can
this
see
doesn't
where.
include 16 and 16 and a half.
Oh yeah, I'd include this whole area. Basically, would be there is 21 current parking spaces in this area right here, and then in this area right here, there's currently 20 parking places.
Okay.
So you can see where they can, kind of jump back and forth and park right in here, or go from here over into here. Like I said, it's almost, I've concreted this whole area and defined it with stripes.
Okay.
So, people could kind of flow in and flow out. And
So it should be easy enough to figure out the ratio of bedrooms to parking spaces.
yes, sir.
Do you happen to know that off the top of your head?
There is 1 bedroom per parking spot.
Okay.
Yeah. I guess we need to add that. Make sure that it's.
Yeah, and
I
know
made a
that's
note
something
of
that
it
Steve
with-
makes sure that we have.
I made a note of it here, John.
Yeah. Okay. Great. Well, anything else you want to add right now? Because you can come back again and rebuttal.
No, I think that I've tried to touch upon everything, adequately, and basically, I guess the rest is in your hands as to decide whether I want to fix up the old building or
Right.
tear it down and add to the other building, which some other people did, which I wouldn't require a variance,
Right.
or come to you and try to do it the right way.
Okay. Thank you, sir.
Thank you.
Anyone who would like to speak on behalf of the appellant? In general comments or opposition? No comment. And you don't have any more to add then. Discussion is closed from the floor. And I'm comfortable if that we add that additional.
Okay, I will.
Okay.
I move that we grant a variance in the case.
No,
It's
I'm
not
sorry,
variance.
it's not variance.
That we grant a substitution of non-conforming use to, in case number 06-15S, Zone R3, located at 18 and 18 and a half Palmer Street, Anthony Farron, appellant. The appellant is requesting a substitution of a non-conforming use, 2 principal structures on 1 lot with a total of 5 tenants, where a maximum of 1 principal structure is permitted, for a not more objectionable use, 2 structures with a total of 13 tenants, with parking deed restrictions.
Second.
Okay. We don't have any
Is there any
discussion.
findings? We need to
Yeah,
just
there's no findings.
determine whether
and
it's more objectionable or not.
I guess with that deed restriction, that satisfies me at least, so.
I think it's a good idea.
Roger? your
Yes.
vote?
Yes.
We have a no from Greg, and I vote yes. So you have your substitution.
Thank you.
Thank you. Okay, what is left to do tonight is disposition of the minutes from March 14. I suggest that we wait till maybe next meeting, so maybe we have other members, unless you have read the minutes.
Sounds good to me.
Okay. Rescheduling of the meeting. I had it marked on my calendar to be here next Wednesday. Is that absolutely impossible if everybody can come? Because David, you were available too, right?
I had it on my calendar.
And Roger, would you be available this Wednesday?
Anytime.
Yeah, the problem with that, though, is that, let me see, Mrs. Hollow won't be here, and I'm not sure where Miss Frederick is, because in back and forth with all these emails, we were trying to figure out, and I thought for sure tonight was one where 5 people would be here.
My impression from the email that I think I have, I don't have it with me, but was that Miss Frederick said she could not be here tonight, but maybe she was available on 31st. That's my impression.
Better to start from scratch again.
What I had recommended, or what I was thinking about recommending to the board was not, because we've been going for almost a month trying to figure out days where we could hold 2 meetings. Finally came up with a night where we thought we could hold 1 meeting, and really, we're just barely able to do that. So I'd recommend that we wait and have the 4 cases that are remaining from the 2 agendas scheduled for the regular meeting on the 13th. That's only about 2 weeks away.
That'll be on Tuesday.
Yeah. Then, what I'd like to do is 2 weeks from then, on a Tuesday, have the meeting that would have heard the cases that were to occur on the 13th.
What would be what date would that be? Do you have? I don't have a calendar.
27th,
Oh, June.
27th of June.
I'll be out of town.
Okay.
Yeah, I'll be
That's
there.
my birthday. You gonna have a cake?
Well, I guess that's why I wanted to have the discussion at this meeting tonight. When can we have another meeting? I don't want to. See, it really makes it hard. Although I know it's hard on appellants and you want to have their cases heard, trying to notify all of them and really get good, sufficient notice
Right.
to parties of
What
interest.
fascinates me is why we could do it 2 days in a row. You could do the 13th and 14th, or 14th and 15th, or
I like to make a comment in here publicly that I think our chair should take a more active role in the organization of this whole meeting. That's what the role of the chair is. And the chair should really be in charge of the scheduling, and because I know this is difficult for you. You have to deal with us and with the appellants. It's not fair to the appellants, it's not fair to us. And that's something that if this responsibility she cannot do, we have to assign somebody who can be in charge of their scheduling and in contacting with people. The number of emails I get from the chair is very minimal. And information I get through you, and some of them are, not everyone is informed sometimes, and this is not fair to the people who come in here, have to wait for months.
Right.
That's all I want to say.
Yeah, it also makes it hard for me to notify, as Mr. Safranek had made mention tonight, when a meeting's canceled, the law director has told me all I have to do is post it on the door. And I don't know when it'll be rescheduled. However, it says on there, if you're interested in the rescheduling date, contact the code office. We give the phone number and the address. And hopefully then we have met the legal requirement for notification. But in reality, it makes it hard because you might call for a meeting just a week later. It takes a tremendous amount of time and energy to look up all these addresses, find all these people, make all these phone calls, send all these letters, and to have to do it over and over and over again. I don't mind doing it, but putting it into really tight, constraints, time frames, where I'd originally thought, yeah, if we could bang out a couple meetings like that, that might be a good thing. it's ended up, as we've gone through just trying to arrange for this meeting, even this one was viewed by a lot of people as being too quick and lacking sufficient notification. So
Even if
maybe
the
we
law
could discuss.
director, even if the law director says it's okay just to put the canceling note on the door just in a few hours before, I don't think that is really truly fair to appellants or even us, just to come in here to see a cancellation notice on the door and walk home. That is just not a good customer service.
I spoke yesterday afternoon to Mr. Hunter about this particular situation, just to confirm that everything that I was doing was, in his opinion, proper. And what I had mentioned to him and what he recommended that I should do is, at the Planning Commission, make a recommendation to them that they revise the zoning code section that talks about membership of the board and add at least one more alternate. Because that's where the problems come in, when we can't get 5 people. And it happens well, I won't say half the time, but I bet we have
should.
we have 3 or 4 meetings a year that are postponed or delayed because we don't have 5 members. So hopefully if I can get that passed and get one more alternate, we'll have a better chance to get 5 people out of 7 than we do 5 out of 6 right now. Because it's hard to, there's just so much contact that has to be done to arrange for all the different people, the appellant, the board, the media, parties of interest. Arranging and organizing all that's hard enough to hit it on a day we all agree to every month, let alone then try to hit it on a day that
So
nobody.
why don't you just go ahead and get another alternate?
That's what I'm going to do. Recommend that the Planning Commission make that recommendation to council to revise the zoning code to add an additional alternate. That'll take, if it's forwarded on quickly, that'll take 3 or 4 months to get that legislation passed.
I also hope that this is not going to create an excuse for most of us to say, okay, we have an extra alternate, so I can maybe schedule something else on my second Tuesday of the month,
We've had this discussion more often than I'd like to think about if any board member, for any reason at all, is not going to be available for a meeting, that they contact me immediately when they know that information. And that way I can stop a mailing, stop a notification, stop a public notice in the newspaper, and try to arrange another day. There are sometimes, to be real honest with you, when I talked to Mr. Lavelle this afternoon, at first he told me, he said, I'm ill and won't be able to attend the meeting. And that's when I thought Ms. Frederick would be here too. So right there,
Yeah.
without even knowing at all, a board member who is well-intended comes to just about every meeting all of a sudden at the very last
There can be
minute.
emergencies, that's for sure.
Right.
Yeah, my daughter
So-
got sick and I had to take her to the hospital.
Right. So I'd just like to say that again. Anytime you know you're not going to be here, let me know just as far in advance as possible. Because I can offer the appellants the option of having their case continued before we even come to this meeting.
Right.
And more often than not, that is what happens. Really, it's just a matter of the odds. It's easier to get 3 out of 5 than it is 3 out of 4 or 3 out of 3. They have that option, though, with 3 or 4 members. So my preference would be rather than do another meeting next week where I have to come in, I'm off Monday, I'd have to come in Tuesday and try to get a hold of people to be here on Wednesday.
Okay.
It's not going to work. And that's why I thought I'd come tonight, recommend that we just wait until the next regular meeting, June the 13th. And I had hoped that we could discuss right now another date somewhere in between June 13th and a July meeting where we could have a second meeting.
Well, we probably have to do it by email because the other people are not here. We don't know what their schedule is and so on.
Right, which
So-
seems to be the problem every meeting when we
And
get
if
into
you would
these.
like to be the
these emails.
person in charge, is fine, but, I think that should be the
Yeah.
chair responsibility.
As
for-
far as I know, because the emails we sent back and forth had to do with everybody's availability prior to the 13th, and now I'm bringing up something in between the June meeting and the July meeting, which I have no idea. I think Mrs. Hollow will be back. She's told me as I recall, she's supposed to be back on the 5th.
Should be tentatively scheduled right now on June 27th, and then
Mr.
find out
Schaff,
from.
right, Mr. Shaffey can't be here
Oh,
on
I'm sorry.
the
Neither can
27th.
Yeah, neither can I, yeah.
But I don't-
Neither can I, that's fine.
Mr. Gruser, if you can be here, and Mr. Golsey.
Yeah,
Or we
I-
can change it to a Monday, a Friday, But I'd just say, try to keep it about 2 weeks away from that. And that way it'll give me plenty of time to do, see the next set of meetings out in between. I still haven't done the public notification on that yet.
I'm on vacation starting.
See,
June
I'm
24th.
even willing to come on my birthday.
I knew that's why I wasn't going that direction. I wouldn't want you to have to do that. I'll get you a cake, though. So, I mean, do we want to tentatively set a date? We've got 4 people here right now, 4 out of 6. As far as I know, Ms. Hollow will be back by then. She's been gone for a month. And Ms. Frederick was gone
If
for
we can
quite
find
a
a
while.
date that suits the 4 of us, it's a pretty
Okay.
good chance
Yeah.
that we can get one of them.
You don't want to have it before June 13th then?
I don't think so. Like I
Okay.
said, the
Between-
cases that would normally have been scheduled for the 13th had to have been advertised, or I had to send them, I had to send the legal notice to the messenger on Wednesday. All right,
What
now,
about
if I
June?
advertise this coming Wednesday for those additional cases that I have, then the meeting could be 1 week away.
Okay.
So that could be on the 20th, let's say, just in theory, on the 20th.
Would
That,
it,
I'd still have time to do that. It would give me a little more cushion to get all the mailing out if we went 2 weeks, or about 2 weeks out.
what about Monday, June 19th? So I don't have to come back from Columbus.
Fine with me.
I'm all right with anything.
Greg, June 19th, Monday. He has to write it.
Is he still in there?
He doesn't have a yes sign apparently.
I think he's gone.
He didn't flash a peace sign or anything like that.
I think
Thumbs
he left,
up?
didn't he?
Hmm?
He left it.
He might have, but I'll tell you, just from talking to Mr. Lavelle, I mean, he works at the library. I see him all the time. Discussions we've had, he's just about, like the rest of you that are here tonight, you're just about always available. Or if you're not, you let me know well in advance. So I'll speak to Mr. Lavelle after the meeting, and I really
So
don't
our
think we'll
next
have a
meeting, a
problem
regular
with it, but
meeting
I'll
on
check on that.
June 13, and then we tentatively scheduled for Monday, June 19,
Okay.
and we should be back on the schedule.
Right. I probably will have, I may not have a full agenda for the 19th, but I have several cases that will be appealed that are
Okay.
coming in. These have to do with not refusals of permits, but notice of violations that I've sent out.
Okay.
Where I've noted a violation, and everybody's, in the course of due process, I can't force you to stop doing something. The first thing you're allowed to do is you have the right first to appeal my decision. In other words, I've made a poor interpretation or an inaccurate estimation or an appraisal. The second thing someone that gets a note of a violation can do is ask for a variance. So, and these are the same kinds of situations where people have done things without permits, and now essentially are exercising their right to appeal.
Would you like one of us to initiate an email right away, contact everyone about this 2 dates, or would you like to do it
I can do it.
tomorrow?
Not tomorrow.
Saturday.
Email
Unless
could
you
be
wanna-
sent. Email could be sent tonight at midnight, or tomorrow, or anytime.
Well, maybe unlike most people, I do have access from remote computers to
Okay.
my work email, but I don't have a computer at home.
Oh, okay.
Steve puts
My-
in enough hours.
my
He doesn't
life
have
is
to
little-
work on
I try to
Saturday.
Would
keep
you
my
like me to
life
send an
insulated.
email tonight to everyone?
If you'd like to do that, John, yeah.
Okay, I'll do that.
Because I don't have a computer at home, and I really don't want to go back to the office. And a lot of times I work Saturdays and Sundays, but I'd prefer not to work tomorrow,
Time
or
is of
Sunday, or
essence, so we
Monday.
need to get,
If you can go right home and jump on the computer and do that, that'd be
okay,
great.
I'll send an email tonight.
Thank you.
A motion? Yes, sure.
There's been talk about the unfairness to appellants of the way that, the procedure's been going, and the unfairness to the board. I'd like to raise another issue, which is the unfairness to people in the community who would like to object. I question the rule that it's okay to just post notice on the door, and then you've got a continuing duty to check and check and check and check and check to see when it's going to come up. that is the people who came here to object to the one, number 3, scrambled. We had 1 day's notice. 1 day. See, it's one thing. And this isn't the best, but if there's no, what happens is notice of the cancellation doesn't actually, people don't receive notice of the cancellation because they come and they see the notice on the board. It comes out an hour or two earlier, or maybe even a half a day, or sometimes a whole day. And so people just don't show up. But they don't go and see anything on the on the door. Nobody shows up because they check and recheck on the phone calls, and nobody shows up. I mean, and again, if the notice of the cancellation doesn't occur until people get in here, and there's at least the chair of the board here, and then there's a discussion at that time, you know, with the appellant and the chair of the board and the people who show up, about when the next date will be at that time, then people have good notice. Okay, it's like scheduling a court hearing in a way, except you got many more parties, and maybe not every party can show up. But you've got notice ahead of time of when the new hearing is, because it's been set at the time of the other one's been canceled. Or another way of approaching it be, you know, maybe if you do want to send out notice ahead of time that it's been canceled, so people don't show up, maybe people can register somewhere that they want to get notice of it specifically, you know, and so that all those people at least can get notice and be hopefully advised more than just 1 day. I mean, yeah, I figured you get 10 days notice the second time. I was wrong, I guess, but we were in another meeting about something totally unrelated, and I asked if, what about rescheduling these things, and Mr. Pearson was kind enough to tell me he was working on it. And then I called down and I thought, I said, nothing's set yet. I said, is the 10 days passed? Well, I'm not sure on that call. And then all of a sudden, I'm slammed. I don't keep calling and calling, and all of a sudden, bam. Yeah, I was able to make it tonight, and it didn't appear at first that Dr. Eland was going to make it, but then, he did make it. Now, Kelly Pirro, who really wanted to be here in person, she got her case across in paper.
We don't have any control over that, though, do we?
Well, I think you could set up
You think the board here?
I think if you set up a notice, if maybe people could register if they want to be heard, and then you can send out notice, and maybe the rules should require that there be some advance notice.
Right. Somebody's going to have to send that out besides us. We're volunteers. We don't get paid for this.
I totally agree with you, and I think we could maybe, if I can't be here, I can send a notice ahead of the time. Also,
and I appreciate your point too. Yeah.
And also sometimes maybe if I say, we have an alternate, maybe if I didn't come tonight, maybe there would be somebody in here.
Well, I'm sure that would reduce.
But I have been on the board for almost 8-9 years now, and I think this is maybe the second or third time. It's not a common thing. We always have had a meeting, and there has been no cancellation. Maybe once in the past or twice, maybe, that I came to the here and found out there was no meeting. It's very rare, so this is not a rare occasion.
In terms of reducing the occasions on which it occurs, the suggestion of getting a second alternate will tend to reduce it, but it doesn't still, that still doesn't solve the problem that
Right, as long
I've
as
raised.
we still, feel that we need to be here on the second Tuesday of every month and give advance notice, that's perfect, and a second alternate would be helpful also. But again, as I mentioned, this is a very rare occasion, one time we canceled because the power was out, I believe, that's the last time I remember. And we couldn't come to the building actually, so, but I do agree with you, sure.
Well, maybe some point you need to look at your rules. Although I agree,
We need
I
to.
understand the practical problem that
Right.
was raised too.
But I agree with that they should be given enough notice that they could conveniently
As it turns
attend
out,
the
we
meeting.
scrambled well, and I was coming down here with the notion of, I might object to the notice, and then I decided, nah, I won't.
Yeah.
We just went ahead.
If you may want to send us a memo to the chair of the board, and maybe we can all get
I
together and
said it.
discuss this.
You
Yeah.
understand it.
Yeah, I do, yeah.
Thank you for your time.
Thank you.
Just so everyone knows, I do have a request list, just as the planning commission does when an agenda is set, whatever time that might be. That agenda is emailed to people who have an ongoing interest. Right now, my email list includes all the board members, quite a few individual citizens, and at least one representative of every neighborhood association. So I'm doing the best that I can right now on trying to get that notice out as quickly to the key people who then have phone trees or whatever to get it out. So I am in contact with, hopefully are the key people, especially in the neighborhood associations. I talked to Mr. Hunter yesterday too to remind him that he had said that he would do some training for the board in your procedures, your operational kinds of things, questions you might have. I confirmed with him yesterday that he still wants to do that very shortly, within the next few weeks. He'd also discussed too that it might be a joint workshop with Nelsonville Planning Commission, Nelsonville Board of Zoning Appeals. But Mr. Hunter still does intend very shortly to go through that training session. I think this would be a good question for him at that time. Is there something that's locked in legally that has to be done, or is this something that could just be amended through the policies and procedures of the board? About 7 years ago, I took over the function of the Housing and Zoning Appeals Board Secretary. That was a 20-hour part-time job that the city had. We were kind of in a budget crunch at the time, and I voluntarily absorbed that half-time position. Between the hours Paul Eschenbacher and I put into it, there's a lot of other things we should be doing. It just adds to our workload. We don't mind doing it. We understand the city has budgetary constraints, and we also know that we have to provide a certain level of service to the community. But I think what's happening here is being illustrated that our service level is diminishing, and how far do we want it to go down before it's not acceptable? So I do appreciate.
Before we get a secretary.
And I think we should share some
That's a
of this
possibility too.
work. I mean,
That's not been mentioned. I don't know if that position still exists in the staffing ordinance. I don't know if there's any money there for that or not. My office used to have 2 full-time and 3 part-time clerical people. I have 1 full-time and 1 part-time now. So the trend is not toward more clerical help.
Squeaky wheel gets the grease.
You know,
Start squeaking.
Steve, what about the Athens city website, that the link to the zoning board is non-existent, I guess. It's been a long time. We don't have a website. A lot of this information could be posted on the website, or the agendas, or
right. I always send, whenever I do establish an agenda, part of that notification email list that I'm talking about that I send out just as quickly as possible is the government channel, and they run the agenda on the government channel. See, because I can get that on instantly. It takes me 4 or 5 days lead time to get an ad in the paper. It's going to take 3 or 4 days for me to type up letters, get them in the mail, and have individual people get them. So I use the best technology and systems that I have available to get as much information to as many people as quickly as possible. If you have concerns about the city website, Ron Forrest is essentially the webmaster for that. he's been working on some changes because I believe council had concerns about the format that the website used to be in. Ron has converted it to a different type of format, which was quite a process, I understand, for him to do. And there are just some of those things where he's not been able to get back to them. We actually had 2 weeks ago, we had essentially our master server melted down, and the city was without electronic communication for 4 days. And it seems like things like that happen all the time. I'm sure Ron would like to build all of the different sites up. But
Okay, because I
again, it's
remember
one of
they
those
used to
things
be,
where there's
yeah.
just so many of us to do so many tasks. The law director's office has been working very diligently, I know Mr. Miller has, on getting the code and the most recent revisions of it up on the city website. And just so everybody knows, those revisions are almost right up to date, where we had a 4-year lag. The law director's office, and particularly Mr. Miller, who's now updating that as things come out. That's one attempt, to try to get the best information and most accurate information available out to people. But it's hard. It's hard. There's just, I don't want to kind of bemoan it, but there's just lots to do and few of us to do it. It's not that we don't want to do it, believe me. So,
Any motion to adjourn?
I motion we adjourn.
okay.
Thank you all.